Coming to you from Chicago, this is GovLove, a podcast about local government. GovLove is produced by ELGL, the Engaging Local Government Leaders Network. We engage the brightest minds in local government. I'm Dan Bolin, a local government attorney and partner at the Ancel Glink law firm in Chicago. Today is a very special episode because we are celebrating 10 years of the American Planning Association Chicago Metro Section Bar Exam Planning Law Session. The bar exam is a simulated law school experience, quizzing planners and local government professionals on some of the most important planning law cases of the year. To make it realistic, it takes place in a bar, and we're going there this afternoon. This is one of my favorite events every year. And to celebrate the 10th annual bar exam, we thought it would be nice to share some of the important cases we'll talk about today with our GovLove audience. But first, we have a partner in Ancel Glink's Chicago office. He counsels public and private sector clients on land use, zoning, construction, governance, and complex regulatory matters. He has extensive experience with economic development efforts, including tax increment financing, annexation, redevelopment, and strategic zoning code projects. Greg Jones, welcome to GovLove.
Thanks, Dan. Happy to be here.
We're happy to have you. Next, we have a partner with Ancel Glink practicing in the areas of municipal law, zoning, land use, economic development, code compliance, and enforcement litigation. She advises clients on a variety of governmental issues, including intergovernmental agreements, development and economic incentive agreements, and zoning and land use controls and relief. Meg and Mack, welcome to GovLove.
Thanks, Dan Bolin.
It is so wonderful to have you. But before we get started, let's start with our signature lightning round. If you would all please tell me about your career path, starting from the day you were born until today. Greg Jones, why don't we go with you first? Since you were, I don't know, ready to go. Let's go.
Well, Dan, it was an unseasonably cool day back in March in the early 1980s, and at that time, I knew that I wanted to be spending this time talking about local government law cases with you on this wonderful podcast.
Is that what the doctor said?
In
the delivery room?
It's on my birth certificate next to my name, which is strange.
Mm-hmm. But what was your place of birth?
I was born in Sparrow Hospital in East Lansing, Michigan, home of Sparty, mighty Michigan State University.
And what happened next?
Well, it's been a wild ride since then. I spent about a decade as a planner and a zoning administrator for a few communities in the Chicagoland area. Then I decided to sell my soul and go to law school and become an attorney. And, this is a podcast, so you can't see me, but I basically wear a Darth Vader helmet every day and embrace the dark side.
No, that's a Kylo Ren helmet. The experience in law school, what made you decide to go to law school after working on the government side?
Sure. Well, I always had an interest in the law and a deep interest in government too. And through my time as a planner, I realized all of the different types of things that municipal attorneys and land use attorneys can get involved with and have an opportunity to influence positive change. And I thought that would be a pretty cool way to spend a career. And so far, so good.
Yeah, you went to law school at night. What was that experience like?
It was dark out.
Was that more conducive to learning, you think?
I don't know, more conducive. It's nice. I was able to continue to grow my professional network and advance on my planning career while doing law school academics at night as well. It was an interesting few years, but yeah, no real regrets.
Neat. And then when did you graduated law school, and then what happened?
And then I went and worked for a firm doing some municipal work, some litigation work, and then I found an opportunity with Ancel Glink here in Chicago, and made the switch over, and I've been here for more than a decade now.
Wow. And when did you meet Dan Bolin at Ancel Glink, and what was that experience like?
I'll never forget that day. It's actually every year I circle that on my calendar. I think it was March 25th, and it's a day that truly lives in infamy.
Hey, yeah, March 25th. It's almost coming up. But in any event, at the time of this recording, if you're listening to this in the future, dear listener, it could be in your recent past, or you could listen to it on the very same day. Now, you are doing, you're a leader in land use and zoning practice, and you're deeply involved with the American Planning Association Illinois chapter. As am I. In my view, it's one of the best chapters out there. What is your involvement with that organization?
Yeah, I'm currently the co-chair of the American Planning Association Illinois Chapter's Legislative Committee, which is a really interesting role. We get an opportunity to kind of engage on primarily state level legislation, but also some federal legislation as well. And especially nowadays, there's just a lot in the planning and zoning realm, including legislation addressing missing middle housing,
Hmm.
parking maximums, responses to grants pass, the increasing homeless issues. So yeah, it's fun. It's a real potpourri. It's interesting and fulfilling in a lot of ways to see these kind of meaty local government topics get more attention at the state legislature, which I think is generally a good thing. That's not to say that all the bills that come out are good, but I think most at least are well intentioned.
Now, this APA Illinois chapter has a Chicago metro section, and for 10 years now, um, they've been hosting this bar exam planning law session. We've been at different bars and breweries and various locations throughout the Chicagoland area, all to accurately simulate that law school experience where that's what I was doing anyway, and where I learned the most, I think. And so, what are some of your favorite memories? Tell me about your experience doing this session over the years. It's kind of, in my view, a great way to share updates on recent cases in a fun and meaningful format. What do you think?
Yeah, I agree. It's a competitive event, so
That's right.
attendees get to team up and pick a team name and kind of put their heads together and compete against other planners in the room, which makes it really fun. So it's you go to a lot of events and there's someone standing up there talking at you for an hour, and we try really hard, and I think have had good success not doing that and trying to make it interactive and fun, and educational, while everyone gets their CLE credit, which next to the bar is probably the most important thing associated with this session.
That's right, and we're like contributing to the economic vitality of the different uh, businesses that we patronize while we're doing these events. Looking
Drink
forward to
local.
doing that.
Drink local.
Yes, exactly. And we are going to give our listeners a taste of this very fun event later on today, and giving them updates on important cases to know for their own local government uh, careers. But meanwhile, and first, we have to talk to Megan Mack. Megan, tell us about your career path. Where were you born?
I was born in Chicago.
Oh, neat. So you haven't gone very far.
No,
At
no.
least today. What happened after you were born? What happened next?
It's shocking how similar my past is to Greg's, with the exception that I was born just maybe a little bit before the 80s. Just a
No.
little, just a little.
No.
Despite my attending law school part-time in the evening, I also decided to have two kids during law school.
I
Just to
mean,
make it a little, it wasn't challenging enough to work full time and go to law school at night. I also wanted to have two children during that experience.
oh wow.
Mm.
That's a that's one way of doing it. That had to be challenging, seriously.
Well, and that reminds me that, the oldest is having his birthday today, as is usually the case,
On the date
of the
of the
bar exam.
record, on the date of the record, the date of this very bar exam, happy birthday to which of your fine
Oh,
children?
Connor Mack again,
Oh,
the
Connor.
one who interned for us,
Oh yes, Connor Mack.
the
Happy
employee of
birthday.
Ancel Glink.
Um, this episode will release after your birthday, so happy belated. But on the day of the record, it is your birthday. Happy birthday. And so tell us about some of the gigs that you held that were similar to Greg's or maybe different um,
Well,
after law
so
school.
right after law school, I worked as an assistant state's attorney in Lake County. So
Mm,
that was incredibly different than Greg's experience.
mm.
And this is my first non-government job.
Yeah,
I sh-
you're
firm experience job.
yeah, you're a firm, but your clients are principally units of local government, is that right?
Exactly, which is why this firm makes so much sense.
Oh, yeah, most days it does, I find. It does make sense. But
Today
that
isn't really one of them, but for the most
yeah, yeah, most days we're going to say like 51% or better. Um, but what other kinds of like government roles did you have before you made
so
it to the Ansel Glink Law Factory?
before going to law school, actually, I was a planner as well, but
Oh,
more in the transportation planning role, working for West Central Municipal Conference and then working for Northwest Municipal Conference. And then when I started law school, I was working for Chicago Area Transportation Study, which no longer exists. And it
hmm.
combined with the NIPSI to become what we now know as CMAP.
What's a NIPSI?
That was Northeastern Illinois Planning Commission.
Oh, see, it's a great governmental entity. It's got
I
a
mean,
acronym.
there's so many acronyms that I can talk to you about. West WCMC to NWMC to CATS combined with NIPSI equals CMAP. And then yes, and then I worked as a Lake County SAO.
Oh, yes. Oh, you've touched them all. That's
I did
outstanding.
also in between work for the city of Chicago in the building department.
Oh, neat. I'm applying for a building permit right now to fix the stairs in front of my house. Can
Good
you
luck.
help?
No,
Oh, thank
no.
you.
What
Um,
happened to the stairs, Dan?
they got old,
Oh,
and
that-
now it's getting warm out, and like things are like warping. But um, so we'll get them fixed though. I'm looking forward to it. Nice spring project. Um, but Megan, how does your like experience working as a planner and in the building department inform your local government law practice today?
I feel like even my little stint at the Park District of Oak Park, all of these experiences play into everything that we do here because I was a prosecutor, I was a planner. They all give great background into everything that we do here when we are in working on ordinances, we're enforcing ordinances, we're working on development agreements, working with elected officials. It's kind this firm is kind of a great culmination of all the things I've done in the past.
Yeah, that's kind of been my experience too. Like I was working in the General Assembly, doing constituent service before I made it um, uh, to law school and out of law school. And it's kind of like doing that at a higher level, I think, like trying to, help clients, help uh, members of the public, just doing the people's work warms my heart every day. Um, and
Before you became the best Ansel Glink law clerk ever.
I did become a law clerk here, and then I was an attorney here, and then I was a partner here, and now I'm a podcaster here,
Right.
which is my principal duties. But in any event, um, I'm just looking at the scoreboard. That's the end of our lightning round. You both have a perfect score. Congratulations. Um, Now it's time to give our listeners a taste of this historic uh, bar exam, and they can experience what some of our Chicago area planners experience every year. But I before we delve into the quiz portion, listeners to this podcast know that we were talking about, and Greg's already mentioned it, that Grants Pass decision from last year, and there was some activity in the Illinois General Assembly yesterday. Greg, I don't know if you got a blurb about that, but while you look that up, um, Megan, would you kindly remind our listeners about what this case is, and and we could talk a little bit about it before we delve into our bar exam material.
Yeah, I'd love to. So before I get into Grants Pass, I think we should also talk a little bit about the case Martin v. Boise.
Yes.
That was a 2018 case from the Ninth Circuit that prohibited the enforcement of public camping ordinances. That ordinance made it a misdemeanor to use streets, sidewalks, parks, or public places for camping. And the Ninth Circuit said that the Eighth Amendment's cruel and unusual punishment clause barred Boise from enforcing their public camping ordinance against homeless individuals who lacked access to alternative shelter. And that access was lacking when there were a greater number of homeless people in a jurisdiction than the actual number of beds in shelters. And so, according to the Ninth Circuit, there were nearly 3/4 of Boise shelter beds were not practicably, oh, that's a hard word to say, available because the city's charitable shelters had a religious atmosphere. And so they went ahead and prohibited Boise from enforcing their camping laws. And then we get to Grants Pass. Grants Pass, Oregon is home to roughly 38,000 people, and 600 of those are estimated to experience homelessness on any given day. So Grants Pass had passed an ordinance that restricted sleeping and camping on public property, parking overnight in public parks, or other related activities. And their penalties were an escalating scale. So, like, your initial violation could trigger a fine. If you had received multiple citations, you could be maybe subject to an order that barred you from being in a city park for 30 days. And then I guess the most extreme would be some prison sentence or a fine of maybe like $1,250. So the plaintiffs in Grants Pass actually filed a class action on behalf of the people there who were experiencing homelessness. And they claimed that the city's ordinance was violating their Eighth Amendment, the cruel and unusual punishment clause, violated their rights. And so the involuntarily homelessness, because of the city's homeless population that exceeded the practically available shelter beds under Martin would apply, and they affirmed it. So about a year ago, before this went up to the Supreme Court, we were encouraging our clients, not to be enacting anti-camping ordinances and to not be banning people from camping and things like that. And then the Supreme Court went and took up Grants Pass and came down on the other side of that. And
Mm-hmm.
we were starting to counsel our clients the other way. And essentially what the Supreme Court held was that regulating camping on public property did not constitute cruel and unusual punishment. And the court did a pretty thorough analysis. I can't remember how long the opinion was, but I feel like it was like 70 or 80 pages, because everybody had their own take on this. But essentially, they said that it did not criminalize status of being homelessness. And so communities were able to enact public camping ordinances. And the court did a very thorough analysis as to, the fact that you could be homeless, and it was not always an involuntary thing as well. And there was a portion of the opinion too that compared it to were you punishing someone for using drugs or drug addiction? And I don't know if you recall that analysis
Right.
in particular.
A status offense.
Mm-hmm. So, and I think, I don't know if Greg wants to jump in, but now I think the concern is there's some legislation
Well, before we get to that, different communities have, I think, responded to different ways to this decision. Like some communities have been adopting the very same uh, punishments and ordinances that Grants Pass had that were upheld in that case. But I think an important part of that case is how limited the holding was. It's just saying that, oh, this didn't violate the Eighth Amendment. And even the analysis in the opinion pointed out that, hey, there might be state laws that apply that might limit how you can regulate and enforce these generally applicable laws against homeless individuals. And in Illinois, and they even pointed to some Oregon laws that were adopted during that litigation that might just do just that. And there's Illinois, there's a Bill of Rights for the Homeless Act,
Right.
and there was a House Bill 1429 that had a committee hearing yesterday. Now, usually during the General Assembly's legislative session, that's what our state legislature is called here. Um, I say don't there's 6,000 bills every year. Um, I usually say, wake me up when it passes one or both houses. But this one's interesting, even though it's just at the committee level at the moment. So the bill would amend the Bill of Rights for the Homeless Act, say neither the state nor any unit of local government may establish or enforce ordinances or policies that include fines or criminal penalties against people experiencing unsheltered homelessness for occupying or engaging in life-sustaining activities on public property. Now, Greg, has this been a bill that the legislative committee's been following?
We are following it, and I've actually spoken with one of the sponsors, and there's about a dozen or so sponsors for this bill. So it's in direct response to Grants Pass. It would substantially limit the ability of municipalities to address and deal with issues related to homelessness by dramatically increasing the rights that the homeless unhoused population has. Dan touched on a little bit of this earlier, but it would bar, for example, municipalities from passing or enforcing an ordinance that imposes fines. The municipalities also could not enforce an ordinance except to maintain public access to property or to address, call it, imminent risks to public health or safety. There are, that generally sounds fair, right? You can enforce ordinances that are intended to allow access. However, this bill includes a number of carve-outs, including notice provisions. So the municipality would have to provide notice before exercising its rights to protect access to property, and it's several days. The notice would have to be provided in advance. So, I think there's a lot of appeal in some corners on the philosophy behind this and trying to protect and enhance the ability of our unhoused population to live a meaningful and life that does not involve intrusion at every turn. But there are also some practical concerns that some of our municipal partners have raised, including, for example, if you're a park district and you have an unhoused person who puts up a tent in the goal box of a soccer field, and it's Saturday morning and all the soccer games are scheduled to take place, can you ask that person to leave, or can you require that person to leave? And there's a reasonable read under this bill that the answer would be no. So I think, to Dan's point, wake me up when it passes either the House or the Senate. The legislative process is iterative, and it's yet to be seen whether or not all of these restrictions that are proposed on units of local government will make it through into a final bill, or if there will be a final bill. But there definitely seems to be room for improvement, and I know that some of the interest groups in Illinois that work with and for municipalities are trying to engage the sponsors to come to a solution or a final bill that seems to balance the interests a little bit more equitably.
Yeah, so listeners, even if you're not in Illinois, I think the takeaway is that there, you might have heard that this Supreme Court decision said that this kind of enforcement was okay for no camping ordinances, but there might be other laws that it's okay under the Eighth Amendment, but there may be other state laws that may already be on the books or could be coming on the books in response to this Supreme Court grants past decision that y'all should keep an eye on. One resource that I'd like to direct to clients to is the Illinois Law Enforcement Response to Homelessness Guidebook. That is, there's a lot of not necessarily enforcement options, but like interventions that are available to law enforcement and municipalities that are detailed there, which are beyond my knowledge and skills as a lawyer, and I'm just a prosecutor. I could prosecute an ordinance violation, but sometimes writing tickets isn't going to resolve the underlying issues that folks are having. So there's resources out there that don't necessarily involve adopting an ordinance or enforcing an ordinance that municipalities can and should consider in addressing these problems. And that's a heavy topic. And I thank you both for talking about it. I know it's been a hot topic on this very podcast, so I wanted to cover it with all of you. But we have important business to attend to, and that's to celebrate the 10th annual APA CMS bar exam. We're going to start quizzing each other with some pub-style trivia questions based on real local government law cases that y'all might be helpful for you all to know. And we're going to start with you, Greg. We're quizzing Greg. This is Megan's case, and
I'm ready.
Well, let's go. So, question one: Linkford City adopted an ordinance that restricts group housing for individuals on mandatory supervised release. The ordinance prohibits more than one person on mandatory supervised release from living at the same address in residential zones, including separate units in the same building. An individual on mandatory supervised release challenges the ordinance under the Equal Protection Clause, arguing that it irrationally discriminates against him. Blinkford defends the ordinance by citing its interests in preserving residential neighborhoods for family use and preventing property value decline. Blinkford already has an ordinance in place that prohibits 3 unrelated persons from living in one household in family neighborhoods. The city files a motion to dismiss the lawsuit, arguing that the ordinance is rationally related to regulating governmental interests, including the preservation of residential neighborhoods and the preservation of property values. How should the court rule on the city's motion to dismiss? Is it A, the court should deny the city's motion to because the governmental interest to pass rational review must be more than an irrational fear by a majority of voters? Is it B, the court should grant the motion, finding that the ordinance was rationally related to legitimate government interests? Is it C, the court should grant the motion, holding that individuals on mandatory supervised release are not a protected class and thus have no viable claim? Or is it D, the court should deny the motion, ruling that strict scrutiny applies because the ordinance affects a fundamental right? Dear listener, lock in your answers. Greg, what do you think?
I'm going to go with C. The court should grant the motion because folks on mandatory supervised release are not a protected class.
Megan, what do we think?
Greg, no.
Oh, no. It can't be wrong.
The correct answer is A. The court should deny the city's motion because the governmental interest to pass rational review must be more than an irrational fear by a majority of voters.
Oh,
So this is based on the Do Not Pass Go versus the City of Rockford case that is out of the Northern District. Came out in September of last year.
Northern District of Illinois for our listeners.
Oh, I'm
yes.
so sorry. The plaintiffs actually are Do Not Pass Go and Next Step Recovery Homes are corporate landlords who provide housing to individuals on supervised release. They sued the city. I hate when I can't read my own writing. So they challenged the city's ordinance for restricting the group housing available in the city for persons under state supervision on behalf of the individuals who are on mandatory supervised release who were seeking to reside in the city under it was a federal equal protection argument. The plaintiffs were obviously responsible for providing housing, in addition to and they were claiming it on their behalf as well as the class of people who are on mandatory supervised release. The ordinance in question had been amended in 2023 to prohibit more than one individual. Oh gosh, that was loud. Sorry, guys. Window noise. More than one individual on mandatory supervised release and other forms of criminal supervision from living at the same address in single or two-family residential zones, which also included multi-unit buildings, meaning that they weren't able to live in the same apartment complex if they were in different units. Under the previous version of the ordinance, individuals on mandatory supervised release were only subject to the generally applicable rule that the city had in place, which barred 3 unrelated people from living in one household in the family neighborhoods. The city enacted this amendment in response to a perceived influx of sex offenders being placed in the city from the Department of Corrections. On the motion to dismiss, the court applied a government-friendly rational basis review to this equal protection claim through a lens of a plaintiff-friendly plausible claim for a relief standard. In a zoning dispute, it's especially difficult to overcome the rational basis test because courts are not willing to act as zoning boards of appeal. So absent a fundamental right of a suspect class for a viable equal protection claim in a land use context, plaintiffs have to demonstrate that the governmental action is wholly impossible to relate to the legitimate governmental objectives. However, the defendants subject to rational review cannot prevail at a motion to dismiss stage, which is where they were at here, by offering just a hypothetical justification for its policy. The city offered the 2 governmental interests: one, to preserve the residential neighborhoods for family use and to prevent the depression of the property values from allowing housing for individuals on mandatory supervised release. And the court did note that both interests were legitimate on their face. As to the first interest, the court reasoned the ordinance already had prohibited 3 unrelated people from living together in a residential area. There was no coherent reason to distinguish between unrelated individuals that were not on mandatory supervised release and unrelated individuals on mandatory supervised release to preserve the residential zones for family use. But the court found that second interest to be more compelling, but still found it to be invalid. While a presumption of rationality applies to a defendant's policy at the motion to dismiss stage, the plaintiffs could overcome that presumption if their well-pleaded facts, taken as true, suggested that the legislature may have relied on shaping the classification, could not reasonably be conceived to be true by the governmental decision maker. And they found that the governmental interest to pass rational review has to be based on more than just an irrational fear by the majority of voters. So because it was at this stage, they said the city didn't show any empirical evidence to justify its assertion that property value is going to diminish by allowing individuals on mandatory supervised release to reside together. So they weren't going to resolve it at the motion to dismiss stage. And they suggested, maybe if the city had had some more empirical evidence to back it up, then it might have actually been a different scenario. But what's interesting is that at the end of the case, the court encouraged the parties to continue to negotiate and work this out together. So I tried to see what happened. I couldn't find where this ordinance is still in place or what the resolution is, but it wasn't dismissed outright, that's for sure.
An interesting case. Greg, I'm looking at the scoreboard. There's a big goose egg under it for you. But I want to give you the
The day is
opportunity.
young. The
I
day
want
is
to
young. Yeah.
I know that you've given speeches on group home cases before. I know you've advised municipalities on these kinds of ordinances. Just to give you an opportunity to redeem yourself. Is there any a tip or two that you want to offer listeners about these kinds of regulations?
Yeah, this is always a particularly fraught area of land use regulation. You've got local zoning authority, but it's kind of superseded by the Fair Housing Act and its amendments, so federal law, and then in some cases there are state laws that also apply as well. So it's you don't. The general rule is municipalities don't enjoy the same regulatory latitude that they normally have in other land use areas. So it makes it kind of tricky, but specifically with the occupancy restrictions, a good rule of thumb is that if you're allowing three unrelated people to reside in a residential unit, that applies regardless of any the status of the person, any disability that may be in play, and certainly, as this case showed, whether or not they are in a mandatory release program as well. So oftentimes when you have these thorny issues, the best advice is to make sure you coordinate closely with your city attorney.
Call your attorney. A great idea. I encourage people to do it every day, and sometimes just call us and ask how we're doing. That'd be nice too. Just say hi. Um, Megan, it's your turn to get quizzed. Greg's gonna tell us about the case. But here's the question. Question two. A group of homeowners oppose Ancel County's zoning board's approval of a variance for a wind farm project, arguing the approval process violated their procedural due process rights because they were not allowed to call additional expert witnesses at the hearing. The zoning board, however, provided them with timely notice, opportunities to cross-examine witnesses, and the ability to present their own evidence. If the homeowners appeal the zoning approval, are they likely to succeed on their due process claim? Is the answer A? Yes, because due process requires that all requested expert witnesses be heard at a zoning hearing. Is it B? No, because procedural due process at a zoning hearing is flexible and does not require all the protections of a court trial. Is it C? Yes, because denying the opportunity to call additional expert witnesses automatically results in a due process violation? Or is it D? No, because administrative decisions are not subject to judicial review. Listeners, I know this is hard, but lock in your answers. Megan, what do you think?
I could see how people might be inclined to think that it's A, that you have a right, that there's a right to call or to request expert witnesses, but I believe the answer is B.
Greg,
Yeah,
what's
there's
the
no due
answer?
process violation.
And like that, she has left me in the dust. Megan's correct. The answer is
Oh.
B. No, because procedural due process at a zoning hearing is flexible and does not require all the protections of a trial court. So this case was out of Knox County, Illinois. Erickson versus Knox County. This is from 2024, so just last year. County residents sued a wind farm company, their county, and the county zoning board of appeals to review a conditional use permit and height variation that was approved by the zoning board and the county board, also seeking declaratory judgment and injunctive relief. The wind farm company obtained a permit to build these tall wind turbine developments that were between 500 and 600 feet in height. The project involved about 60 wind turbines, so it's a larger project in the grand scheme of things. And the taller, newer wind turbines that they were proposing were more technologically advanced and efficient than the older, shorter ones. The total investment for the project was about $170 million. So again, not a small project, and was intended to create jobs, and improve roads, and generate tax revenue for the county. During the hearing, the wind farm, so this is the applicant, they called numerous witnesses to testify to the benefits and talk generally about how great the project was and how it complied with all local, state, and federal regulations. The angry neighbors came out and they called a few witnesses of their own to testify that the project would still be functional and not prejudiced if it was required to use the shorter turbine size that was less technologically advanced. Objectors also brought up issues concerning noise and other hardships the county residents thought they would endure if the project was approved and built. This hearing didn't occur on one night. It occurred over the course of 3 nights, so it was continued twice. And on the last night of the hearing officer denied the objectors' request to call further expert witnesses to testify and provide additional feedback to the board. The objectors were upset at this, stating that they wished to call additional experts and were denied the ability to do so. They sued and argued that the approval violated their procedural due process rights because the objectors didn't have enough time to prepare for the hearing, and the zoning board limited their ability to call an expert witness. The trial court sided with the county. They dismissed the objectors' claims, finding that the residents had timely notice and meaningful opportunities to participate in the hearing, including cross-examining witnesses and be heard by the ZBA. And the appellate court, up on appeal, affirmed. So they agreed with the trial court. They agreed that the county's procedures were sufficient. The operative language out of the trial court or out of the appellate court opinion is that due process is flexible and calls for only such procedural protections as the particular situation demands. In the context of this hearing, it is well recognized that not all of the accepted requirements of due process in the trial of a case are necessary. So the court here made a distinction between due process rights that are afforded during trial and those that are afforded during a ZBA hearing, and found that the two are different. The court noted that the plaintiffs had meaningful notice and an opportunity to be heard. They extensively cross-examined the defendant's witnesses. They presented evidence and they called their own witnesses. Also, the objectors didn't show how the experts that they wanted to call at the third night of the hearing would be integral to the action of the ZBA, or that the lack of their testimony would deprive the ZBA or the objectors rather, of a meaningful opportunity to be heard. So this is a helpful reminder. I think ZBA proceedings, local zoning proceedings can turn adversarial, and they often do. And when that happens, some folks have the misinformed belief that these are court proceedings, which they are not. It's a public process. Everybody has an opportunity to provide input. There are absolutely due process rights involved in this, but it's not the same as being in front of a judge or a jury. And the procedures used at these zoning hearings can and often are far more flexible than what you would see in a typical traditional court setting.
I think that's good advice. A good point. Something that we often encourage folks to do, ZBAs, plan commissions, is to adopt rules that can let people know the kinds of things that the chair is going to be empowered to consider in the presentation of evidence. The chair doesn't need to allow irrelevant evidence or redundant evidence. And in here, the objectors didn't show that the other witnesses that they wanted to call were going to contribute anything new to the proceedings or more valuable to proceedings. And so that's something that is valuable for plan commissions and chairs to have, and zoning boards of appeals to have those rules, and have those rules empower your chair to apply them flexibly. It's going to be different for this kind of contested hearing versus the small routine side yard variation. So good case to know, informs your practical practice and experience for our listeners, I'm sure. And Greg, we want to give you a chance to bounce back and get on the scoreboard here.
I need all the help I can get.
All right, question 3 here. A developer sued Glink Village, claiming that Glink's use of eminent domain and other land use decisions violated his equal protection rights under the 14th Amendment. The village had taken land for road construction and later returned it. But the developer argued that the village's decisions were discriminatory and motivated by personal animus against him. What must the developer prove to successfully claim a violation of equal protection based on a class of one argument? Is it A, that the village's decisions were made arbitrarily without any justification? Is it B, that he was treated differently from others similarly situated and that there is no reasonably conceivable rational basis for that difference in treatment and the difference in treatment was intentional? Is it C, that the village acted with malice and intent to harm him specifically? Or is it D, that all the village's decisions were incorrect or unfavorable to him? Listeners at home, I'm sure you're wondering, why are these questions so hard? That's because the bar exam is so hard. We are trying to make this a realistic experience for you. Greg, what do you got?
So I know that these equal protection class of one claims are particularly difficult to bring in any context, not just in the municipal context. So I'm going to go with B, that he was treated differently from others that were similarly situated, and that there was no rational basis for the difference, and that the community acted intentionally to treat him differently.
Megan, what do you think?
Well done, Greg. You are on the board.
Yes.
Nice.
So this is the Greenwald Family Limited Partnership versus Mukwanago. Gosh, how do you say that?
That's got to be a Wisconsin place,
Mukwanago.
Right?
It is a Wisconsin case. Mukwanago is a municipality 30 miles southeast of Milwaukee. So I think what's interesting to know for the background of this case is that the Greenwald family brought this, I think after they ran into some development issues with the village of Mukwanago, because from 2003 to 2013, they were getting along swimmingly with that village. And then when they started to run into development challenges, they then filed this lawsuit. So the developer, the Greenwald family, challenged the village's use of eminent domain to take land from their 5-acre parcel for road construction. Interestingly enough, the village returned the land, but the developer had filed an amended complaint, including a class of one equal protection claim under the 14th Amendment. And they pointed to 6 adverse municipal decisions regarding its properties, but they focused really on 2 decisions. The family was convinced that the new village administrator personally had it in for them. The first decision involved the developer's proposal to buy a plot of land that left the sellers with a remnant parcel. The sale was contingent on municipal approval for the land division that required a certified survey map and the developer plan that outlined the construction of an access road so that the sellers would not lose access to their remnant parcel. Because the developer did not provide this information, the request was denied and the sale was canceled. The village later ended up buying that same parcel of land and developed it itself. The second decision involved a road that the village planned to construct across one of the developer's parcels. The developer opposed the taking and the village began the eminent domain process. After the developer sued the village, alleging that the taking did not serve the public and was intended to harm the developer, the village returned the land, acknowledging that it would help the developer in an ongoing transaction for that parcel. After the land was returned, the village amended its complaint to include a violation in its equal protection after the land was returned, actually, the developer amended the complaint. The village then removed the case to federal court. The district court granted the village's motion for summary judgment and found that a rational basis for each of its land use decisions that the developer had complained of. To succeed, the developer would have needed to have shown that it was treated differently from others similarly situated, and there was no reasonable, conceivable, rational basis for the difference in treatment. And the court found that the village made each one of its land use and public funding decisions based on taxpayer costs, commercial benefits, land use planning objectives, and other community needs. In other words, the village acted rationally and was guided by factors of municipal land use and development body would be expected to consider. Although the developer cited various communications from the village administrator, which seemed to show personal animus towards the developer, the court found that the communications didn't matter since the village had ample justification for its decisions. And the court noted that although the plaintiff or the developer was disappointed landowner, it was not the victim of unconstitutional discrimination.
So, Megan, what's one takeaway from this case that listeners should know?
It's very difficult to prove a class of one discrimination case, but also on the government side, as long as you can point to, a rational basis, which there was no doubt that the village had a rational basis here, such as, public funding decisions that were based on, commercial benefits to the area, community needs, that they were going to be able to sustain any objections that were done for the decisions that they made. And they could uphold all of the zoning decisions that they had gone through when they were facing proposed development plans.
Megan, it's bottom of the ninth, tie score. We've got one question left. Time for one more question.
You're gonna make me sweat this.
Either you're gonna go for the win. I'm thinking of. I feel like I'm Steve Harvey on Family Feud, but those are different rules where the other team can steal. But in any event, let's get to it.
What's the prize, Dan?
We'll have you back on the GovLove podcast.
Amazing.
Question 4. A religious organization challenges a Glink village zoning ordinance, arguing that it discriminates against religious assemblies by requiring them to apply for a special use permit, while some secular organizations would not have had to apply for a special permit. However, the church never applied for a special use permit, and the church never bought property in the village. Is the church likely to succeed on its challenge? Is the answer A, yes, because ordinances that do not explicitly permit churches in any district are per se unconstitutional? Is it B, no, because the church never applied for a special use permit, so it cannot demonstrate it was treated unfairly compared to secular organizations? Or is it C, yes, because the church wasn't able to purchase real estate in Glink Village?
No
Greg,
pressure, Megan. No pressure.
Oh, yeah, Megan. Oh, it's Megan's question.
Oh,
Megan,
I forgot.
No pressure.
Yes.
you forgot already?
B.
Well, I forgot.
No, because the church never applied for a special use permit, so it cannot demonstrate it was treated unfairly compared to a secular organization.
Greg, what do you got?
Megan, you've bested me yet again. The correct answer is B. You win the fabulous prize. Still waiting to find out what that is.
Well, tell us about the case, Greg.
Sure. So this is a case involving a religious institution in the village of Hazelcrest. It's Word Seed Church versus Hazelcrest. This is a Seventh Circuit decision, federal appellate court in the district that covers Illinois. The church sued the village, arguing that the zoning ordinance discriminated against churches in violation of the Equal Protection Clause and the Religious Land Use and Institutionalized Persons Act, commonly known as Res Lupa, and was unconstitutionally vague. While the church was searching for a permanent location, it identified the village as a possible location, but the church wasn't able to find a location that was big enough to hold its growing congregation. The church claimed, however, that their trouble in finding a location resulted from the village's discriminatory zoning ordinance. The ordinance established 9 different zoning districts, 4 residential, 2 business, 1 limited manufacturing, and 1 for planned developments. And none of those zoning districts identified churches as a permitted use. This meant that the church would have to apply for a special use permit, which was a multi-step and public process that involves time and money. In addition to claiming that the ordinance was unconstitutionally vague, the church also argued that by not including churches as a permitted use in any of the village's 9 zoning districts, the village denied it the ability to meet freely as of right. By forcing religious groups to go through an onerous and expensive, that's their words, the church's words rather, time-consuming and overly discretionary process to obtain a special use permit, the village had imposed burdens on religious assemblies that were not imposed on non-religious groups. And the church argued that violated the Equal Protection Clause of the 14th Amendment and Res Lupa. The district court, so that's the trial court here, they granted the village's motion for summary judgment and denied the church's claims, finding that Res Lupa did not apply because the church never had a property interest in any real estate located in the village. Further, the ordinance did not violate the Equal Protection Clause because the church never sought a special use permit, which precluded the possibility of discrimination against the church. And the church did not show that they were treated worse than any comparable secular organization, and that there was no property in the village that could accommodate the church's needs. The court also rejected the vagueness challenge raised by the church, and it found that the zoning ordinance in this community was similar to zoning ordinances in other communities that impose special use regulations. So this is an interesting case. This was a church that seemed to want to preemptively invalidate a zoning ordinance without going through all the necessary steps that a litigant typically has to, namely either buying a property or going under contract on a property, getting some form of property interest, and then filing an application and seeing if the community approves the application or denies it. The church took none of those steps here. Instead, it appears that they identified the community, took a look through the zoning code, and said, it might just be easier to sue as opposed to go through a public process. To which both courts, district and appellate, said, no, thank you.
Incredible, good case, great game, gang. I'm really thrilled that you joined me here today, and for all the years that you've done the APA CMS bar exam with me. It's one of my favorite events every year. I look forward to seeing you. I look forward to seeing the planners. Thanks to you. Thanks to APA Chicago Metro section for having us back every year, even though the questions are really hard and the rules are super unfair and the host doesn't always know what he's doing. But Megan's the big winner today. But before we head out there and see everybody at the live bar exam event, but part of your prize, Megan, in addition to having you back someday, you get the last question. If you could be the GovLove DJ, what song would you pick as the exit music for this episode?
Oh my God. Seriously?
Yeah.
I got nothing. What would you pick, Dan? I mean, you are the GovLove DJ, but
probably the Family Feud theme song. It's my favorite show. I
had no idea you were such a fan of Family Feud.
Specifically Celebrity Family Feud. We love it. It's the number one show in our house. And so, I say let's close out with that music. And with that, I'll say that ends our episode for today. Thanks to everyone for joining me to celebrate the 10th annual APA CMS Bar Exam Planning Law Session. GovLove is produced by a rotating cast of ELGL volunteers. ELGL is the Engaging Local Government Leaders Network. You can reach us at elgl.org/GovLove or on LinkedIn at GovLove Podcast. Thanks for listening. This has been GovLove, a podcast about local government. I'll see you next time. That's what Steve Harvey says.